Well, we want to speak to our Patrick Amimo, who is at the City Center studio here in Nairobi, just to give us more details about this particular bill. Thank you very much, Patrick, for joining us this afternoon. Let's talk about the things that we cannot do. What kind of information is this that we will need to have probably guidance or some sort of authority to have?
Indeed. Thank you so much, Betty. Maybe just to bring you up to speed on why we should have this access to information bill, why it's important for it to be enacted. This bill is meant to operationalize Article 35 of our Constitution, which deals with access to information. Remember, in the past regimes, we've been dealing with cases where there's it's been very difficult to get information from government ministries or departments. Oftentimes, officers cite the Official Secrets Act, and even if it was information that's supposed to in public domain or it's not very sensitive information, we've always had government officials hiding behind the Official Secrets Act. So with this bill, which has been initiated by the Nyeri County Women MP Priscilla Nyokabi, it will operationalize Article 35 to ensure that every Kenyan or member of the media fraternity access this information as fast as possible. And indeed, there are provisions where they say that this information, if it touches on the life of a person it concerns life or liberty of a person, such information should be released within 48 hours. And the maximum period that has been given for the information to be released is 21 days. But where information is complex and maybe it might require some time, the bill provides that it should be released within 15 working days. So there are provisions within which an individual must access this information. It's not an open check. There are time limits, timelines within which the information must be provided, and if not, the public officer in charge who is declined to release such information is liable to a fine or even imprisonment. But to get to your question on some of the provisions in the bill where information might not be, the public might not easily access that information, is to do their provisions where they say if such information will undermine national security, the national security of Kenya. The other provision is that if such thing will impede the due process of law or endanger the safety or life of any person. And maybe in terms of national security, we're looking at terms of where there's a military operation. If it's something to do with the deployment of troops in maybe in, let's look at a situation like a cattle rustling area, or maybe on our borders, look at, say, in our border with Somalia, maybe there's something that there's a military operation. Such information, maybe they might not give us the exact numbers of officers who are involved in this particular operation, the strategies that will be involved in ensuring that they deal with those criminal elements, and also maybe the number of ammunition and the caliber. Such sensitive information will not be surrendered to the media fraternity. The other area is where such kind of information will involve unwarranted invasion of the privacy of an individual other than the applicant or the person on whose behalf an application has been made. So if it's if they feel that that the information would be getting into someone's privacy unwarranted, then such information will not be easily accessed unless you give reasons on why you feel that you want to get that information, unless if it's in public interest. But if it's infringing on one's, if it's an invasion on privacy, then such information will not be easily given out. The other area is to do with the infringement. If it infringes on the commercial interest or intellectual property rights of a commercial entity or a private entity, then such information, if it's to do with commercial interests or is infringing on intellectual rights, then such information also, there is a provision that that particular body or department or entity might argue that this information is touching on my intellectual rights or commercial interests, then that information might not be released because it might give undue advantage to a competitor. The other area where the information is limited is where it could damage a public entity's position in any actual or contemplated legal proceedings. So if it's the area also where it infringes on legal professional privilege, such areas also it's limited. You might not access such information. But in other areas, there's that freedom that you can access whatever information you want from either ministry or a department. Betty?
All right, Amimo, so who exactly is going to be making this decision on which information is can be released and the information that cannot be released? Who is that person?
There are those public officers. If it's in the case of government, there are those public officers heading such departments, particular departments. So if you are a public officer and there is a member of the public or the media wants to access certain information that is within your mandate, then you have to release that information. If it's not touching on national security, if it will not infringe on commercial interests, you're supposed to give that to release the information within that stipulated days, 48 hours up to 21 days. That information must be released to that particular individual who is seeking that information, and it's the public officer who has access to that information. The other area is that this information also should not be levied. It should be made in a manner that is so simple, and a member of the public should access this information without putting roadblocks to him or her that maybe we need to give such amount. Maybe we could look at an area of maybe making photocopies. If that information will require photocopies, maybe those are the only ones, the only area where we might look at and say maybe I've used 10 shillings or 20 shillings to make this particular photocopies, so that one I might levy you to get the information. But the information is supposed to be free. And also the other area that is very good with this particular bill is that there is a protection of a member of the public who will give information that which according to him or her is of public interest. Such information, if it's withheld and a member of the public feels that discloses such information, that person is protected under this particular bill. The person will not be victimized. So in so doing, this one will also, the bill will encourage whistleblowers who will have something of public interest out there. And again, it's not that this despite the provisions that some information might be withheld, where it's held that the information in that is in public domain or is of public interest, then such information will the public officer in charge will be forced to release such information to whoever wants to have it. Betty?
Right. Thank you very much, Patrick Amimo, for that report there.